This is our second video about Model Rule 1.10, which is about imputation and screening. And this is what are we talking about? When a lawyer at a law firm has that individual lawyer has a conflict of interest, usually because of their prior work at another firm, that could impute to the whole, we could impute that conflict to the whole firm. You may have remember way back when I started talking about 1.7 and explained disqualification of a lawyer due to a conflict of interest, where a judge throws you off of a case, even though your client wanted you. Not only would you be disqualified, your firm would be disqualified. And in practice, I got to say, this is a point of litigation. We get appellate decisions about it. It's a big deal. It's a big deal for a whole firm to get thrown off a lucrative lawsuit that they were hoping for. And so I'm using this image here. This is part 2, where we're talking about the comments. And see that empty chair? That's where you're going to go sit in the library to avoid everybody at the firm when they're talking about this case, because we're going to screen you and, so that your conflict won't be imputed to everybody else. So let's go through the comments to 1.10 as quickly as we can here. I think you've gotten the idea. For purposes of the rules of professional conduct, the term firm denotes lawyers in a law partnership, professional corporation, sole proprietorship, any other association, practice law. Notice this also applies to legal service, legal aid clinics, or the department, in-house counsel, the legal department in a corporation, and also to the legal department at in a government entity. So just keep that in mind. We talk about firm, but we really mean a law office, and it could be the legal department for in-house counsel. This rule would apply, and it could also be, let's say, the DA's office or the U.S. Attorney's office or something like that. Now, the rule of imputed disqualification stated in paragraph A gives effect to the principle of loyalty to the client as it applies to lawyers who practice in the firm. And such situations can be considered from the premise that a firm of lawyers is essentially one lawyer for purposes of the rules governing loyalty to the client, and from the premise that each lawyer is vicariously bound by the obligation of loyalty owed by each lawyer with whom the lawyer is associated. Wow, well, that's a bunch of blah blah just to explain that, of course, we're going to impute, if one lawyer has a conflict, we have to worry about whether the other lawyers in the firm will be tainted by that conflict. Now, this paragraph A1 operates only among the lawyers currently associated in a firm. And when a lawyer moves from one firm to another, the situation is typically governed by 1.9b, 1.10 and 1.10b. The rule in paragraph A does not prohibit representation, whether neither questions of the client or loyalty or protection of confidential information. I think that's supposed to say where. That must be a typo in the rules. Are presented. When one lawyer in a firm could not effectively represent a client because of a strong political beliefs, for example. And so an example I gave earlier is, let's say that you are passionately devoted to the cause of stopping abortion. You are pro-life to the core. You've spent years advocating for this, and so forth. It's a very strong commitment. You could have a material limitation conflict of interest if you were asked to represent an abortion provider like Planned Parenthood or a doctor who does abortions. And the same is true the other way. If you are passionately pro-choice and you've devoted a lot of time and emotional energy and things like that to advocating for abortion rights, then being asked to represent a pro-life group or a group of people who protest outside abortion clinics or something like that could mean that you have a conflict of interest. And we could go on and on with examples, but that's a really contentious example in our society where people tend to have absolute views. You know, I don't mean that many people who are moderate on abortion, like who think that we should find some kind of compromise, but that is a conceivable viewpoint. We have compromise and moderates and centrists on a lot of other issues. But people tend to have very polarized views about it, and so that can affect who they represent. And there's a number of other issues like that. So let's say that that's you. But if you're not going to work on the case and your beliefs aren't going to affect anybody else from the firm, they're just going to ignore you, and you're going to keep your mouth shut, then other people in the firm could represent that client who you disagree with so very strongly. On the other hand, if an opposing party in a case were owned by a lawyer in the firm, and others in the firm would be materially limited in pursuing the matter because of loyalty to that lawyer, the personal disqualification of the lawyer would be imputed to all the other lawyers in the firm. So here we're talking about, let's say there's a really scary managing partner, one of these people that goes around screaming at everybody. Everyone's terrified of this lawyer. He dominates the office, he fires at will, and so forth. And then you are trying to represent someone who's suing a company that is owned by your managing partner. Well, even if we screen, if that your managing partner, if he says, by the way, I don't forgive and I never forget, or something like that, right before we start screening him, and everybody's a little bit scared, or if he kind of, does one of these things where I'm watching you, don't mess with me, then of course we're going to impute the conflict of interest. Comment 4 is about the non-lawyers in the firm. You could get a test question about this, and I want you to be aware of it. The rule in A also does not prohibit representation by others in the firm where the person prohibited from involvement in a matter is a non-lawyer, such as a paralegal or a legal secretary. A does not forbid representation if the lawyer is prohibited from acting because of events before that person became a lawyer. For example, work that the person did as a law student. So, for example, if you are a law student watching this video and you've been doing internships, you should keep a personal file, some personal records or archives of every matter that you have worked on, because when you go through your legal career, you're going to need to inform your employers, wait a second, I have a conflict. So just keep track of the names and the nature of the matter. Like, I represented XYZ. I worked on a case when I was a law student intern for XYZ Corporation, and it was commercial litigation, and the opposing party was such and such, and a company or something like that. And just keep records of it, because even though you're not a lawyer yet, that could affect you, and we could have to screen you from future cases. Such persons, however, ordinarily must be screened from any personal participation in the matter to avoid communication to others in the firm of confidential information that both non-lawyers and the firm have a legal duty to protect. This would also be true, it's not just what you did as a law student. If you worked at a job for a while, a non-law job, and then went to law school, so you worked for a while between college and law school, and now you're a lawyer at a firm, and your firm is representing someone who is suing your former employer where you worked a long time, we'll probably need to screen you, right, from this case. Okay, comment 5. This rule, 1.10b, operates to permit a law firm under certain circumstances to represent a person with interests directly adverse to those of a client represented by a lawyer who formerly was associated with the firm. This rule applies regardless of when the formerly associated lawyer represented the client. However, the law firm may not represent a person with interests adverse to the client, to those of a present client of a firm, which would violate 1.7. So please note that we don't allow this type of screening if you're currently representing someone. Make sure that's kind of a rookie mistake, right, for professional responsibility. You can't have lawyer A, like attorney Stevenson at the firm representing the plaintiff, and attorney B, we'll call him attorney Smith at the firm representing the defendant in the same case. I know I made clear earlier that you can't have the same lawyer trying to represent both the plaintiff and the defendant. You also can't have the same firm doing that. That's concurrent conflicts of interest under 1.7. No screening for that. Screening applies to former legal work, former clients or something, or your personal views or political commitments or religious commitments or something like that that could interfere with your representation of a client but wouldn't really affect anybody else in the firm. Moreover, the firm may not represent the person where the matter is the same or substantially related to that in which the formerly associated lawyer represented the client, and any other lawyer currently in the firm has material information protected by rules 1.6 and 1.9. So if you leave a firm and the client leaves with you, your old firm could represent someone opposing to them, but they can't jump in to the same matter on the other side, right? And so that it looks like the firm that was really the attorneys of record for the plaintiff is now the attorney of record for the defendant. We can't do that. We could sue our former client because they've left with you, as long as nobody in our firm knows anything about them. And so in some cases that's true, in other cases it won't be. Rule 1.10c, this is comment 6, removes imputation with the informed consent of the affected client or former client under conditions stated in 1.7. So maybe you go back to your former client and say, by the way, I'm now working for this firm, and they're like, oh, we don't care. And so they give informed consent in writing, right? And you will have to give informed consent confirmed in writing to the conflict if they decide that you don't care. Comment 6, in some cases, the risk may be so severe that the conflict may not be cured by client consent. Remember that you could have something where it's a non-consentable conflict because it's extreme circumstances. And okay, and then they reference the effectiveness of waivers of future conflicts from comment 22 and 1.7, and I will refer you back to a previous lecture where we talked about that. And the definition of informed consent, there's a whole lecture I did on that. 1.10 removes imputation otherwise required by Rule 1.10, but unlike Section C, it does so without requiring that there be informed consent by the client. This is comment 7 to 1.10. And remember, this is what I was telling you. If you have the type of conflict where we can screen the lawyer, we just provide notice, we don't get consent, although they could consent, right? And then you don't have to bother screening. It requires the procedures laid out in sections A2, little 1 to little 3 be followed. Lawyers should be aware, however, that even where screening mechanisms have been adopted, tribunals may consider additional factors in ruling upon motions to disqualify a lawyer from pending litigation. And so you can adopt screening, but it's not foolproof. We could have circumstances where the firm where the court agrees to disqualify you. I have seen some cases from the last few years about 1.10. Honestly, the troubling ones involve paralegals, and it's a firm that we have long protracted litigation, and so they hire a paralegal from the opposing counsel's firm specifically for the purpose of trying to get confidential information and get a strategic advantage in the litigation. And when that happens, the court doesn't care that you have put on some sort of pretext or charade of screening. If they can see through what you're doing, then they can still disqualify you. A2.1 does not prohibit the screened lawyer from receiving a salary or partnership share in the established by prior independent agreement. But the lawyer may not receive compensation directly related to the matter in which the lawyer is disqualified. And so don't worry if you are told you're going to be paid a certain salary and your paycheck is the same after law school from week to week, it's going to stay the same even when we screen you. What we're talking about, again, just to remind you, is if you are screened from a case and then that case generates some kind of windfall fees or income for the firm, and they decide to just immediately distribute this sort of newfound surplus to everybody, instead of giving everybody a raise or something like that, you don't get any. Comment 9. The notice requirement in A2 little 2 should include a description of the screen lawyer's prior representation and a statement by the screen lawyer and the firm that the client's material confidential information has not been disclosed. Basically, we want you and your firm to both certify that you haven't divulged information and the firm is certifying they haven't received any. And the notice should be given as soon as practicable after the need for screening becomes apparent. The notice is intended to enable the former client to evaluate and comment upon the effectiveness of the screening procedures. This is comment 9 to Rule 1.10. Let's talk about certification. This is comment 10. And wow, isn't this dry? I don't know how you can stand listening to this. This is actually, I'm boring myself just going through this. I think you get the idea, but here we go. Comment 10, the certification required by paragraph A23 gives the former client assurance that the client's material confidential information has not been disclosed or used appropriately, either prior to timely implementation of a screen or thereafter. Compliance cannot be certified. If it can't be, then the certificate must describe the failure to comply. If the lawyer sat down and said, oh, let me tell you about that case, and shared a bunch of stuff, before we had a chance to screen them, then you have to say, here's what they told us, this lawyer told us. And then Rule 11, comment 11 to Rule 1.10 merely restates the point that, from D, that if a lawyer has joined a private firm having come from a government lawyer position, we have a whole separate rule. We don't apply 1.10, we apply 1.11 to that. I gotta tell you, the rules are very similar. They're very, some of the verbiage is verbatim between the two. But just keep in mind, we have, if it's a government created conflict of interest from your government employment, then we're going to be under 1.11. And I don't think I need to explain that too much. Okay, comment 12. When a lawyer is prohibited from engaging in transactions under 1.8, I mentioned this at the outset of this video, paragraph K of that rule, and not this rule, determines whether that prohibition also applies to other lawyers associated in a firm with the personally prohibited lawyer. And so please note that those types of conflicts, we did impute everything except sex with a client, which was 1.8J, impute to the rest of the firm. And go back to 1.8K and look at that. We don't quite have the same screening procedures there that we do here. This is a long review question. I'm not going to read it out loud on the video because I'm afraid you'll fall asleep. I would encourage you to test your knowledge, though, and hit pause on the video and read the question, make sure that you can answer this. And if not, you may want to review this rule in this video. So this is a sample question about 1.10.